Hi, everyone. Thanks for joining me again for another installment of my Wills and Trusts 101 series. If you haven't watched any of the previous ones, I really like to just go over very generally what estate planning documents are and give you a little bit of background on what you can expect when you're doing your own estate planning documents and how they can benefit you. But before we get into all of that, I want to introduce myself. So my name is Alyssa Chow. I am an attorney here in the Sacramento area, and I actually am born and raised in Sacramento. So Pocket area, Green Haven, I went to McClatchy for high school, even though my parents all went to Kennedy, so they're not super pleased about that. But I also have a lot of experience with ACC and the general community. I was, volunteering a lot when I was younger with ACC. You probably, at least pre-COVID, when we had activities here, might have seen me either bussing tables or passing out food for the various activities that were here. I am also on the board of the Sacramento Asian Sports Foundation, so I'm currently the vice president and secretary there. So you probably have also seen me passing out food for the crab feed or other fundraisers that happen either for ACC or for SASF or other organizations in the area. And as is very, if you've seen any of the previous presentations that I've done, as is very common, I always have to give a shout out to my mom. So if anybody knows Sue Chow, she is a very avid pickleball player in the community, and she does play at ACC. So if you ever see her, just let her know that I did give her the requisite shout out, and I have, met my duty as a good daughter to do that. And before we get started too, just wanted to let everyone know, if you haven't done so already, go to the ACC website and download the upcoming class schedule for this upcoming quarter. You'll be able to download it as a PDF and just see all the different programs that ACC has to offer coming up. All right. So just to start off, I like to talk about what really is estate planning. A lot of people, I think, when they think of estate planning, they think of either a will or maybe some other specific legal documents, which we definitely will go over today. But there are some other types of estate planning that a lot of people engage in that they don't even really realize that they're doing any sort of formal estate planning. So one of them is, beneficiary designation. So most people will have something like a retirement policy, some sort of life insurance policy or plan, and possibly even your investment accounts or maybe bank accounts. Now, if you can always, you can look into naming a beneficiary for those types of accounts. There are some limitations, though, for what the actual implications are when you do name a beneficiary. And so in many cases, it's important to talk to an attorney or someone who is familiar with either the implications of possibly naming a minor beneficiary or someone who has any sort of special needs or maybe is on public benefits. And so even though it's not normally considered a type of estate planning, beneficiary designations are key as part of your overall estate planning portfolio, and something that you really want to consider as far as who those beneficiaries are, whether it's appropriate for them to receive any of those funds outright, or what the implications of that would be. Another type of estate planning that I have up here is taking title to property. So anytime somebody purchases a piece of real estate, or if you own a bank account or any other sort of asset jointly with another person, taking title to property is in and of itself a form of estate planning. So normally, if you own an asset jointly with another person, let's take a bank account, for example. If something happens to you, then whoever the surviving person is on the account is going to generally be the sole owner of any assets that are left inside of that account. It's not uncommon where I hear clients tell me that they have their adult children on those accounts with them so that their children will have immediate and direct access to any of the funds that are in the account, just in case they need to access them to pay for bills or deal with any other sort of financial issues on behalf of their parent. But there are some downsides to doing it that way. One potential downside would be if your child that you put onto the account with you has debts of their own, or if they are going to possibly be a litigant in a lawsuit, then the funds that you have added them onto now look like they belong to them. So just for potential liability purposes, it's one thing to consider as far as an estate plan when you do add somebody onto your own bank account. With real estate, it's even more potentially impactful with how you decide to take title. There's a couple of generally different ways that individuals can take title with other people. One of them is as tenants in common. And so normally with a tenancy in common style of taking title, what that means is that if something happens to one of the tenants in common, whatever their portion of ownership of that property will actually stay with them. So if they were to pass away, they could have either dictated where that asset should go, or what ultimately ends up happening in many cases, if they did not have an estate plan of their own, is it will probably have to go through the probate court system in order to get to whoever their heirs at law are. Another way of taking title to real estate can be something like a joint tenancy. So with joint tenancy, comes with it what's called right of survivorship. And with the right of survivorship, what that means is if one person passes, the other person is going to be the surviving owner. It's almost like a survival of the fittest type of taking title. And I would say most spouses tend to take title that way. And in California, too, we have a very specific type of way to take title with a spouse, which would be what we call community property with right of survivorship. Now, it's really important as far as titling goes to make sure that you have that with right of survivorship language if you do take title as community property, because if you don't have that right of survivorship language attached to the title, then if something happens to one of you, it's actually treated as if it was a tenants in common situation. So the way that individuals take title, for better or for worse, will be a form of estate planning in and of itself. And so that's something that I always talk to clients about, wanting to double check and just make sure that there's no potential issues that would come up just in case you were to pass away or become incapacitated. And so otherwise, though, I would say that we are going to be more specifically talking about legal documents today. So a revocable living trust, last will and testament, durable power of attorney for finances, an advanced healthcare directive are most commonly going to be the main estate planning documents that most people will have in a more formal estate planning portfolio. Oh. All right, so let's talk about a revocable living trust. Oh, I do want to apologize. I think my hair was rubbing on the mic a little bit, so I'll shift my hair out of the way and hopefully it won't impact the sound. So just let me know if that happens again, okay? All right, so diving in a little bit more into the revocable living trust. Really what a revocable living trust is just a legal contract. And really that legal contract is meant to provide any sort of instructions for control, management, and distribution of assets. And really when we're doing an estate planning portfolio and considering something like a living trust, it really is meant so that you can leave those really clear instructions behind for whoever it is that you do leave in charge so that they can properly administer your affairs for you. And it's done in a way where they feel very confident that they're following whatever your instructions were. And as far as the revocable living trust goes, I like to think of it as really just a legal key to whoever it is that you leave in charge. The person who you leave in charge in the context of a living trust is referred to as a trustee. And so a little bit different than an executor, which is under the context of a will. But when you do a living trust, the trustee is the person who would then follow all of your instructions. And so the trust is really, that key in order for you to be able to gain access to any of the assets that are properly titled within your living trust. Okay, so let's talk about proper trust funding. I think one of the most common mistakes that I see a lot of people do, especially when they may have done an estate plan or a trust 20 years ago or 10 or even 5 years ago, is that they may not have actually done the proper trust funding for the trust to actually work for them. So based on this breakdown that I have here, only the following assets are going to be considered properly what we call funded into your living trust. So one of them is going to be, assets that are titled in the name of the trust. And what I mean by titled, that means that whenever you're initially creating your trust, you'll have a name of your trust. So for example, my name's Alyssa Chow. My trust could be named the Alyssa Chow Living Trust. In order for that asset to be properly funded, or for any assets to be properly funded into my trust, I would actually have to, for example, go to the banks to retitle those accounts so that it actually shows ownership in the name of the Alyssa Chow Living Trust. That is actually one way that you're making a formal link between that asset and all the instructions that you've put together. Another example would be like with real estate. So we talked about different ways that individuals can take title. Instead of all of that, if you were to own a piece of property and you own it with a spouse, for example, instead of seeing both of your names on there with either that joint tenancy or possibly community property with right of survivorship language, then you would actually see the name of your trust on there. What that does as far as access goes is, if you can imagine for a piece of real estate, if I were to become incapacitated and my spouse needed to be able to sell the property or do anything, encumber the property in any way, if it was just in my name or possibly just in both of our names, my spouse might run into some issues if I'm incapacitated and unable to sign off on any documentation related to any transactions for the property. Now, if we do have the house titled in the name of our living trust, though, then if something happens to me, the trust instructions would already say what happens if I become incapacitated. So most commonly, what happens is that my spouse then could continue to be the sole trustee managing the trust, and then they could proceed with doing anything as far as a transaction that's necessary related to the property. And so when I talk about the trust really being a key granting access, that's just one example of the functionality of a trust, either upon incapacity or even after I've passed away. There's also another way to properly fund a trust, and that's going to be by designating a living trust as a pay-on-death beneficiary. So I have a couple of examples up here, and I did reference them before, but for example, you might have a retirement account or a life insurance policy, and you may want to name the trust as the pay-on-death beneficiary in a certain situation. With retirement accounts, that really normally you'd want to name your spouse as the primary beneficiary, but part of the estate planning process is to evaluate who is going to be the most appropriate individual or the most appropriate method for either connecting your trust to retirement accounts or life insurance policies, and possibly having the instructions of your trust control any of those funds upon your passing. I do want to note that assets that list beneficiaries directly and don't have a living trust listed as that beneficiary will actually pass outside of the trust. And so if I were to list my spouse as the direct beneficiary of my retirement account, then upon my passing, assuming that my spouse survives me, they will actually be able to claim those funds, and any instructions I would have otherwise had in a trust are not going to control what ultimately happens to those assets. And so I think another mistake that I see a lot with people who come to me who maybe already did their trust in the past is that they see that there was what we call Schedule A, or sometimes some form of Exhibit A that was attached to their trust. And maybe that document lists out all their bank accounts that they owned, all the real estate that they might have owned, but that's the furthest they went when they created the trust. They didn't move forward with either recording a deed to put the property in the name of their trust, and they didn't go to the bank to either retitle the accounts or to name the trust as a pay-on-death beneficiary. So I think that's probably one of the biggest mistakes that I always see. And one piece of making sure that that trust can properly serve as a key to accessing any of those assets is to stay up to date on making sure that those assets are properly funded into the name of the trust, because things change over time. You know, we get rid of assets, we acquire new assets, sometimes we refinance property. So it's really important to stay up to date and to just monitor the assets that you do have so that whatever is left at the time of your passing, it is properly funded into the trust. Okay, so another document that I think most people are more familiar with is what's called a last will and testament. So there's a couple different types of last will and testament. For the purposes of this presentation, I'll be going over a more traditional standalone last will and testament, but also a pour-over last will and testament. So first, to go over a standalone last will and testament, that type of document is going to be if you didn't do a trust and you use that document to state where you want your assets to go upon your death and who should be in charge of making sure that that is all handled appropriately. The other type of last will and testament is what's called a pour-over last will and testament. And that type of document is really only done in the context of a living trust. Now, let's say you put together all of your really beautiful trust instructions, you thought that you properly funded everything, but upon your passing, you completely forgot about some bank account at Golden One, or maybe another account that you opened because you needed to in order to create a safety deposit box or open up a safety deposit box. Now, that account is left just in your name individually when you've passed away. So a pour-over last will and testament basically just directs whoever is in charge of your trust to go forward and make a claim on whatever those funds are, whatever that asset is, to essentially scoop it up and pour it over into the trust. So a pour-over last will and testament is really just a backup document so that we can redirect assets to the trust for ultimate administration of your assets as time goes on. So when we look at a last will and testament and kind of the differences between that versus a trust, I think that's probably one of the biggest questions that I get from a lot of people is, well, okay, what is the difference? And why should I do either both or either of the documents? I think one of the most common misconceptions that I hear whenever people say, well, if I have just a will, shouldn't that be enough? And unfortunately, that misconception is that they can avoid probate if they do a will. While you do still get the ability to choose who would be in charge of handling your affairs and ultimately where your assets would go upon your passing, in many cases, a will is going to have to be administered in the probate court setting. What a lot of people don't know is that the probate court is the only entity with the authorization to really oversee the administration of a will. And so depending on, there's obviously caveats to whether or not a will has to go through probate, but for the most part, a will defaults to the probate court as far as the entity that would oversee that will's administration. So before we get into too much, I do want to talk a little bit very briefly about the probate court. I don't know if anybody who's tuning in right now has ever had to deal with a probate court system before, but I do regularly practice in the probate court as well as part of my general practice area. And when it comes to a probate court administration, or really any time you have to deal with the court system, for individuals who either have insufficient or no estate planning documents at all, the probate court will really just oversee the administration of the estate of either an incapacitated individual or a deceased individual in California. I can say that in Sacramento County in particular, it's a pretty lengthy process, especially with COVID and a lot of court closures and disruptions in the way that the administration of the courts have been facing. We are looking at, if you do have to deal with a probate administration, you're looking at probably somewhere between 1.5 to 2 years before all of the assets can properly and ultimately be distributed to your intended beneficiaries, whether you have an estate plan or not, or whether you have a will or not. It can also be incredibly expensive. And so without going too much into the weeds of what the fees and costs are, generally speaking, when it does come to a full probate administration, you're looking at thousands of dollars more than you possibly would have to deal with in a trust administration context. And with the probate court in particular, there are a bunch of third parties that are also entitled to fees and costs. And so normally, and actually, that also depends on whether everyone gets along in the process. So if there ever is any sort of conflict among the beneficiaries, or the beneficiaries are not happy with how the person who's in charge, whether it be the executor or the administrator, if they're not happy with how things are being handled, sometimes that can delay and even make the process much more expensive as time goes on. So we, generally speaking, with all of these estate planning documents, are looking to avoid the probate court system as much as possible. And finally, getting to really, what is the difference between a will versus a trust? So a will, as we've talked about, will likely require probate. When I say that it will likely require probate, what I mean by that is in California, there is a threshold value for what would otherwise require probate administration if someone were to pass away, either not leaving any estate planning documents behind or leaving only a will, a last will and testament as their estate planning instructions. So that number right now is if you have assets that are worth over $166,250 in value that you either don't own jointly with someone else or that you don't have a beneficiary designated for, then you are probably going to have to go through probate if all you did was leave behind a will as your instructions. It's also a very public forum. So especially with COVID now, all of the courts generally have gone to either Zoom or WebEx or Microsoft Teams, some form of virtual viewing and participation in any of their court proceedings. So it's a little bit strange, but if you were to appear for any sort of hearing in the probate court, you would log on, and if it's a Zoom hearing, you can see 50, 60, sometimes 70 people who are also logged on and just waiting for their matter to be heard. But with that being a public forum, it does mean that anyone can gain access to the information that's being discussed during the hearing. And in certain situations, in most of the documents that are going to be filed in a probate administration, anybody can gain access to those documents and actually either pay to download them or access them online. And another big difference for a will, if we're looking at that versus a trust, is that it is effective only upon your passing. So if you ever were to become incapacitated at any point, the instructions that you have in your will are not going to serve you personally in any way, because that document only becomes effective and essentially triggered upon your passing. The difference with a trust, though, is that with a trust, again, as long as it was properly funded and all of the assets that you had either had beneficiary designations or were funded into the name of the trust at the time of your passing, that really shouldn't require any probate. And so then effectively it can be privately administered. A lot of the times when people come to me after a loved one has passed away, the last thing that they want to do is have to deal with any of the extra steps or bureaucracy related to the court system, and it really should be handled privately because the instructions that their loved one put in place for what should happen upon their passing, are very sensitive, and many people wish for those terms to be private and kept within the family. So one benefit to the trust, of course, is that it is privately administered. And the other benefit of a living trust is that it is effective during your lifetime and upon your death. So whereas the will, again, only become effective once you've passed away and will just dictate what happens to assets and where they should go, a trust will also have provisions in place which will say that if for some reason you are incapacitated and your successor trustee needs to step in, maybe they need to make sure that your care costs are being met and they need to access your funds to do that, then a trust and making sure that the assets are properly funded into the trust are going to really serve you personally because you don't have any delay or any sort of confusion as to who should be in charge to manage that for you and on your behalf, and how those assets should be managed for your benefit. Okay, So a couple of other documents that are also really important in the context of your estate planning portfolio are going to be your powers of attorney. And in California, powers of attorney are generally going to be broken up into two different categories. So the first one that we'll talk about is the durable power of attorney for finances. Now, with a durable power of attorney for finances, this type of document is really meant to supplement anything that a living trust maybe is not covering for you during your lifetime. So earlier we talked about how real estate can be titled in the name of a trust, or bank accounts can be titled in the name of your trust, but some assets like your retirement accounts or life insurance policies might have to stay in your name individually because those passed by beneficiary designation. Well, that's all good and well if you pass away, but if you were to become incapacitated at any point and elections needed to be made on your retirement, or maybe you needed to make some changes to the required minimum distributions, then you need someone who's been effectively appointed as your agent who can step in and manage all of that for you. If you've ever seen what a power of attorney looks like, there's a couple different formats of it. But generally speaking, it's going to cover any and all financial matters, including maybe the less fun but very necessary financial matters such as filing taxes, dealing with insurance, dealing with any outstanding bills or creditors, or even possibly acting on your behalf in any sort of litigation or other ongoing matters. So really, when we're doing a durable power of attorney for finances, you are choosing an agent who would basically be stepping in and acting on your behalf regarding finances during your lifetime, and that would be effective even if you are incapacitated. So really important. I think a lot of my clients who have children who are named as their agents or even their spouse, it's a really important document because it really is another type of legal document that will grant access to whoever it is that you have designated has that authority to step in. And then the other power of attorney is going to be your advanced healthcare directive. I think most people are familiar with a healthcare directive in the sense that almost any time you go to the doctor and you're checking in, they always ask you, do you have an advanced healthcare directive? And some people do, some people don't. I know that some institutions like Kaiser will just give out an advanced healthcare directive to fill out, and that's perfectly fine. But it is really important that you consider doing an advanced healthcare directive because in doing so, you are appointing also an agent, basically someone who can step into your shoes for you, to make any medical decisions for you during your lifetime if you can't express what your preferences are directly to your healthcare providers. And this would include anything related to treatment, types of treatment, withholding of treatment. And part of the Advanced Healthcare Directive is that you also get to determine whether you wish for measures to be implemented to prolong your life or not to prolong your life. And you really get the opportunity to list out what your preferences are as far as medical treatment or end-of-life decisions. One distinction I do want to make, which is something that I've been talking with a little more recently with clients, is an Advanced Healthcare Directive is different from what we call a POLST form. And a POLST form is a POLST, stands for Physician's Orders for Life-Sustaining Treatment. That document you would actually do with your physician because it is a physician's order, and that's going to cover more very specific types of treatment in the event of very close to end of life. So it would cover things like whether you can be resuscitated if you go into cardiac arrest, whether any sort of artificial nutrition or hydration should be applied under certain circumstances. And so that document is something that you may want to consider looking into with your physician, whereas I would say that an advanced healthcare directive is really more important in the context of determining who you feel the most comfortable with appointing to make those medical decisions on your behalf. And, kind of inherent in everything that we've been talking about today is that whenever you're considering who your successor trustees should be, or who your durable power of attorney agent should be, or your advanced healthcare agent, you really want to decide who's the most appropriate person who should step in for you. And do they have any experience in making these sorts of decisions or dealing with these sorts of affairs? I mean, they don't necessarily have to be a bookkeeper or have to have dealt with multiple probate matters or trust administration types of matters in the past, but it is very beneficial if they are generally organized, if there's someone that you can speak open and freely with about what your wishes would be, then the more that they know and understand about you, the better the better position they are in order to enact your wishes as you've written them out. Okay. So some of the benefits of estate planning that we've talked about, kind of just to summarize, is really we want to avoid the probate court system. A probate court is really going to be the court of last resort. I would hope that you wouldn't have to deal with the probate court system at any point, either during lifetime or after passing. But if we can, to the greatest degree possible, try to minimize any of your possible need, right, to have to deal with that court system. The other benefit of estate planning, in the sense of doing at least a living trust or some form of powers of attorney during your lifetime, would be ease of administration of your affairs according to your wishes. So if you don't take the reins and decide that you want to put down what your preferences would be in the event of incapacity or death, the state of California is going to assume on your behalf what you would have wanted to have happen. So there's not only an order of priority in most cases for who the person would be, for who could step in and handle your affairs for you, but there's also an assumption under the probate code and just under California's laws about who you would have wanted your assets to go to. And so it is really important, as far as control goes, that you be able to identify who you would want to be in charge and how you would want assets to be handled. We also covered the benefit of privacy, right? So if you do proper estate planning to avoid the probate court system, then you can effectively privately administer your affairs. And also efficiency. Like I mentioned with Sacramento County right now in particular, you're looking at 1.5 to 2 years before you can get a full probate administration completed. And that's not even including all of the additional costs and expenses of having to wait for that long. Okay. And so, who is estate planning really going to be appropriate for? At a very base minimum, every adult, once you turn 18, the age of majority being 18, every adult should at least have a durable power of attorney for finances and an advanced healthcare directive. Really, that's going to be really important. I have some clients whose kids are just now going off to college, and you want to consider what happens if they get in an accident or something happens to them. Then if they don't have powers of attorney at a base minimum, either allowing you or any other person that they choose to be their designated agent to manage their bank accounts or their bills or making medical decisions for them, then the default in California is that you have to go through the probate court system through a process called conservatorship. And that process is even more lengthy and expensive and involved and invasive than a normal probate administration would be if we were dealing with post-death administration. And so at a base minimum, we do want to at least have those powers of attorney in place. Another couple categories for why a living trust in particular is going to benefit someone is if you have any minor beneficiaries. So in California, minors can't receive funds outright. What that means is that I've had clients in the past who, when they first come to me, maybe they have a 2-year-old and a 2-year-old and a 5-year-old, let's say, and they named them as direct beneficiaries on their life insurance policies just in case something happened to them. And of course, their thinking behind that is, well, if something happens to me, I want to make sure that my kids are taken care of and that they have funds available to support them if they need anything, right? If they need health care, they need any sort of educational costs covered. And unfortunately, because California does not allow minors to receive funds outright, what that ultimately and most of the time results in is the need for what we call a guardianship. And that's pretty counterintuitive for most people, especially if you do have a surviving parent. I have dealt with a few cases in the past where husband and wife have 1 or 2 minor children, and they maybe named their spouse 50% beneficiary on a life insurance policy, and then named their children, minor children, as 50% other beneficiary for, let's say, a $500,000 policy, right? Unfortunately, I've had to break the news to those clients that while the surviving spouse has no problem with making a claim on their 50% of that life insurance policy, the children have no capacity to fill out the forms or to make a claim with the life insurance company. And even though their surviving parent is there and they live with them, they're legally their parent, they need to establish a formal guardianship with the probate court in order to be able to claim the funds and manage the funds on behalf of the child or children. And in many cases, because that parent still owes a duty to support that minor child, they can't even use the money that's been allocated for the minor child without getting formal court approval to do so. So a living trust is really going to be appropriate for anyone who has minor beneficiaries who would possibly be receiving any sort of life insurance proceeds, any real estate, definitely, or any other funds. And there's some caveats to that as well, but generally speaking, that's going to be a really good estate planning tool for them. Another reason why you may want to consider a living trust is for beneficiaries who just aren't really good with money. I sometimes have clients who say, oh boy, I can't imagine my kid getting half of every, maybe they have two children, one's really good with money, the other one's not, and they think, oh boy, I don't really feel comfortable with my child, one of them, all of a sudden getting half of everything that I own. I'm really worried about how they're going to use that money or how quickly that money is going to be spent. And so part of the benefit of doing a living trust is that you can really control how and when your beneficiaries would be receiving their inheritance, even if they are adults. And kind of similar to that, a little offshoot of that type of subtrust is also a possibility for creating what we call a special needs trust or a supplemental needs trust. That type of trust as a subtrust from your main kind of umbrella trust is going to be for any individuals or any beneficiaries who are on public benefits. I have some clients whose children have developmental disabilities and who are going to be relying on public benefits, and so they really don't want them to inherit a bunch of money that would otherwise disqualify them for keeping those public benefits in the future. So it doesn't quite fall under the same category of beneficiaries who are not good at managing money, but it is a possible solution for making sure that they can still receive their inheritance and maintain their public benefits. And then finally, I know I talked about this number earlier, but a living trust really is going to be most appropriate for estates that are worth over $166,250 worth, or for any real property. Any real estate, generally speaking, is going to probably require any sort of probate action upon your passing if you don't have a trust and if that property is not properly funded into the trust. Okay. So that is the end of my presentation. I know we have a few questions that have come in, so maybe we can talk about those, and I'll maybe read those off. Let's see. Okay, so first question is from Janice. Janice mentioned that her parents had an AB trust and that they had to split the assets to an A and a B trust. But if a person does not have an estate of $11 million, which within 2022, that's gone up to even about $12 million. But if you have less than the amount needed for an estate tax, any sort of estate tax planning, do they split to A and a B, or is there a step up in basis? So that's a couple of different questions, I think, contained in that question. It is common for, I would say, trusts that were done 20 plus years ago to require what we call an A-B split. And what that really means is that they were trying to minimize any of their estate tax burden. And the way that it's set up is that when one spouse passes away, they try to shelter certain assets from having to pay estate taxes into an irrevocable trust. So it basically splits off so that there is a survivor's trust and a decedent's trust. And the benefit of that, of course, is the estate tax if you even get the benefit. But now, because the estate tax exemption amount is so high, these trusts now, even though they require the AB split, maybe it's not necessary. There's a couple different ways that that can be handled. It really depends. I have to give you the classic attorney response, which is it depends on how that should be handled. Normally in situations where I'm presented with that issue, I would look at the specific terms and what the trust actually provides for and how much of a requirement it otherwise would have been for an AB trust. The most conservative way that you can attack that sort of issue, though, is to get a court order just clarifying or modifying the trust so that it can all stay one single trust as opposed to requiring that split. The question of the step up in basis, so I do have to give the disclaimer that I don't talk too much about taxes or tax law as part of my estate planning advice. And I think for the purposes of this presentation, it's probably not the most appropriate to talk about step up in basis for assets. But generally speaking, I can say that when you do pass away, certain assets get a step up in tax basis to the fair market value of that asset on your date of death. With an AB trust, it's much more complicated and depends on the type of AB trust that was set up. Because each AB trust is also going to have its own specific tax language that may or may not affect whether you get not just one but two steps up in basis for that property. So it really just depends, and I'd have to take a look, or you'd need to get an attorney to take a look at that. Okay, so the next question from Martha is, if I have no children or other relatives or friends to whom I can entrust roles like a trustee, powers of attorney for finances and health, etc., would I be able to hire someone like you to take these roles? And so, Martha, you're not. That is very common that people either don't have children or don't feel comfortable, even if they do have children, with naming them in any of those fiduciary capacities. Myself as an attorney, if I'm the one drafting the documents, it's not really appropriate for me to be a trustee or an agent for you, but there are professional fiduciaries that are out there. And in fact, I will be, I think in my next presentation, we'll be bringing on Shannon Downs. She's a California licensed professional fiduciary. And basically, she's licensed and bonded by the state of California. And there's lots of other private fiduciaries out there in this very unique role where they would basically be individuals who you would appoint as either a successor trustee, agent for finances, or healthcare. And you would talk to them and let them know what your preferences are and basically hire them to be the individual to manage your affairs for you. So when Shannon comes on, if you go to the website and you see what day, I don't know off the top of my head when I'm coming back for that, but if you look at the website and you see what the upcoming schedule is, she'll be on and we can talk a little bit more about some stories about types of cases that she assists on and also what her role as a professional fiduciary would be. Oh, I am told that the upcoming presentation is on February 2nd, and that would be at 4 o'clock p.m. Okay. Next question is, can a family member, such as grandchildren or in-laws, contest a trust? Ooh, that's a good question. So whenever someone passes away and they did create a trust, certain individuals are entitled to notice that they've passed away and that the trust exists. Those individuals are going to be whoever the specific beneficiaries are, but also whoever your closest living heirs at law are. Under the probate code, typically that's going to be if both spouses are gone for a joint trust, for example, and they have children, then those children are going to be considered heirs at law. And so they would be entitled to not only notification that the trust exists, but also a copy of the trust. So another attorney response, which is it depends, but depending on who your closest heirs at law are, they would be entitled to notice of the trust existence and also a copy, and could possibly try to contest. The hard part in California, and I think it's probably the same anywhere in the US, but anybody can really file a lawsuit for any reason, and whether or not they are going to be successful at that is one thing, right? But there are some situations post-death where certain individuals do have a form of entitlement to at least getting information about the trust and its existence. Okay, so the next question from Janice was, her children are young adults, but they don't have much money, not even $10,000. Is it okay for them to have to just have a beneficiary, or if they're just going, if they have, I think that means joint accounts. So for any young adults who don't have a lot of money, it is absolutely fine for them to designate a beneficiary on their bank accounts. And in fact, I think a lot of people don't know that you can name beneficiaries onto your bank accounts. So that's not a problem at all. They just want to be cognizant of who they're naming as the beneficiary and whether that person is a minor or someone who has capacity to manage any funds if they were to pass away. If the other part of that question is about having joint accounts, it's also not uncommon for people to have joint accounts with their children, but the only potential hesitancy I would have there is the warning that I said earlier in the presentation, which is that if something happens and let's say you and your adult child are both entitled to a bank account together and they get in an accident, for example, then any of those funds that either belong to them or maybe if you put them onto your accounts, any of those funds would possibly be reachable in any sort of ensuing litigation. So you probably just want to be cognizant of any potential liability issues there. Another person said, what about a transfer on death title for real estate? Still valid, question mark. So I know that there is something called a transfer on death deed, which was a little bit of a, I guess I can refer to it as like an experiment that the state of California tried to see if that type of document or that type of transfer would be a little bit better than a living trust if all someone has was a piece of real property. I think that law has sunsetted as of 2022. The legislature, unless they decided to extend that any further, I don't think that they actually decided to extend it come 2022, but I'm not certain on that. It did get extended once in 2021. It was supposed to sunset, but it did get extended to 2022. So I think that any transfer on death deeds that were not executed prior to January 1 of this year are not going to be valid any longer, but I'm not entirely sure on that. Let's see. Do you know about Safe Harbor Trust? I'm not sure about a Safe Harbor Trust. If that might be in the context of possibly like an irrevocable trust style, but I'm not sure what the Safe Harbor Trust. I think this is the first question that's stumped me in one of these presentations. So sorry, Lucy, I'm not quite sure about the Safe Harbor Trust. Tim says, what is the cost of setting up a trust, and is there a worksheet that lists the information needed to set up a trust? So there's lots of different options that are available out there for setting up a trust. I would say in the Sacramento area generally for an individual trust, you can probably expect to spend somewhere between maybe $1,500 to $3,000 for an individual trust package. And with a joint trust, maybe somewhere between $2,000 and $4,000, really depending on the level of expertise of the attorney who's preparing it. I would caution anyone against using legal document preparers from doing their estate planning documents, really just because those individuals are not authorized to give any legal advice. All they would be doing is just plugging in information for you, and they wouldn't be able to customize it for what your needs are if you do have any specific requests. So if anyone has questions for me personally about rates or if anyone has questions about my rates, I am offering free consultations. So if you want to reach out to me, we can chat about rates, specifically if I were the one to do your estate planning documents. And I always provide a worksheet, a confidential client questionnaire where I would collect all main data about my clients, including any and all assets and beneficiary designations as they may currently be set up. Okay, Joyce said, how do the trust and will work together? I assume the trust distributes only those in the trust, and in a will you spell out, for example, who inherits your personal treasures. So if we do the pour-over will in the context of a living trust, normally what we say is just any and all assets, including personal property assets, would be handled under the terms of the trust. And then within the trust, or at least I break up personal property distributions in two different ways. So first, I have a general umbrella statement for any and all personal property items that are left at the time of your passing, and those personal items would be things like, jewelry, art, heirlooms, furniture, vehicles, any of those tangible items. We would give a blanket statement of what should happen to those, whether you leave it up in the trustee's discretion for what to do with those assets, or leave it equally to certain beneficiaries or to only one beneficiary. And then the second way that it would be handled is through a specific list that you can fill out, designating a specific name of a beneficiary and a description of the item or items that you wish for that person to receive. Okay. Let's see, next question. Oh, thank you, Martha. Martha said wonderful. Ernest said, do I have to revise the will and trust if one beneficiary passes without any heirs, or will the existing documents divide assets to remaining beneficiaries listed? As far as if something happens to a current beneficiary that you have designated, it really depends on the way that your trust is set up. One way that sometimes people will set up a trust is to the issue by right of representation of a deceased beneficiary. And so what that basically means is that, let's say you have two beneficiaries, one passes away, and you say that if they were to pass, that their portion should go to their issue by right of representation, then that means that their children would step into their shoes and receive their inheritance. If you don't have that issue by right of representation, or sometimes it's also referred to as per Stirpes language, then the default may be that it just all goes to the surviving other beneficiary or multiple beneficiaries. So you'd have to take a look at the specific language that's in your trust, and if it doesn't provide for what you would like to happen, then you may want to consider an amendment. And that kind of brings up also a good point. So Ernest, I'm really glad that you asked that question, which a lot of people will ask me, how often should they have their trust reviewed or possibly updated? And I think it's a good idea maybe every 5 years or so, 5 to 10 years, to meet with your attorney to have things looked at, because family dynamics change, relationships change, and assets change. So it's always good to have almost like a little tune-up, I should say, for the assets that you have and the instructions that you have. There's not really a need necessarily to meet with your attorney every year to have things looked at, but I'd say as a general rule, maybe somewhere between every 5 and 10 years, or if there is an actual change that happens in your family dynamic or financial situation, then it's a good idea to have your documents looked at again. Okay. So I think that's all of the questions. Again, if anybody has any further questions, I am offering free consultations for anyone who's viewed this presentation. So just let me know that you viewed the ACC presentation and you were here for the seminar. And I'm happy to look over either existing documents that you have and give you some suggestions and maybe come up with a game plan for updating, or even talking to you about doing brand new documents. So thank you again so much, and just as a final reminder, go ahead and go to the ACC website to download the upcoming class schedule for all the upcoming programs, and I'll see you next month for my upcoming presentation. Thank you.
Thank you. Thank you very much. Thank you. Thank you.
Thank you. That was great. Very good. Thank you.
Yeah, thank you.